6th, and we have in front of us H2, which deals with delinquency jurisdiction, but also is an amendment that incorporates some ideas that I've been working with Eric on, given testimony that we've had related to race, age, and juvenile justice. So are you you're not going to you don't need to put it online, where I think we're fine.
Oh, yeah, I didn't think of that.
That's good.
You sure?
Well, you don't have your information.
Should run back and grab it.
No, but we're good. It's available for those in the viewing audience online, so people can see it there. So over to you, Eric.
Thank you, Chair Lalonde, and good afternoon, everybody.
Good afternoon.
Nice to see you. Eric Fitzpatrick with the Office of Legislative Counsel, as the chair said, here to walk the committee through a proposed amendment to H2, which you may recall I walked the committee through a couple of weeks ago. And in fact, if you either have a hard copy of the proposed amendment or are looking at it online, either way, the very first page of the amendment is H2 as it was introduced. So in other words, that's what I walked you through a couple of weeks ago. You may recall, and the amendment is broken up into different topics, which if you look again at page 1, line 5, I'm sure you've seen this in many bills so far. These are what's I didn't realize till recently. I just called it, the asterisks with the heading, but they're actually referred to as reader assistance among our editorial staff. So hopefully it does assist the reader, but so it provides a topic. Tells you, it's these next section or sections are dealing with this topic. And in the first one, as I mentioned, is on line 5 on page 1, has to do with the jurisdiction of the family division over delinquency proceedings. So you remember that when it comes to juvenile jurisdiction, the age range that the family division has jurisdiction over children is it starts at age 10 and goes up to age 18. Now, of course, there's, as you know, some exceptions that bring in to raise the age, but leaving that aside for a moment, generally speaking, age 10 to age 18. So if a child commits one of those, an offense that would otherwise be criminal, is brought into the family division on a juvenile proceeding if they're either age 10 or through age 18 currently. So section 1 of the bill, which was also the only section in H2, bumps that lower age up by 2 years to 12. So right now, a 10 or 11-year-old that committed what would otherwise be a criminal offense could be brought into the family division in a juvenile proceeding. Proposal is raise that age up to 12, so a 10 or 11-year-old would not be subject to juvenile proceedings anymore. Not to say that their unlawful conduct couldn't be relevant in a CHINS proceeding or some other proceeding where DCF was looking to take custody of the child or something of that nature, but it would not be a kind of proceeding that could be done as a juvenile. That's section 1, and as I say, that was already walked through in H2 originally. So what's the new provision you'll see over on page 2? Now, if you think about the way that that jurisdiction of the family division, you may recall you had, and many of these sections do respond in one way or another to testimony that the committee taken or discussions that you've had over the last couple of weeks on these juvenile matters. This one has to do with, you may recall the idea that, well, sometimes when young people get charged in the family division as juvenile proceedings and they happen to be near the threshold of when they're going to age out, right? 17, 16, sometimes something like that. There isn't as much of a deterrent or an incentive for them to comply with their probation because they're going to age out soon. Right? Pretty soon they're going to turn 18. And you look at page 2, line 4 and 5, generally speaking, family division can't extend jurisdiction beyond the child's 18th birthday. So they hit 18 and they're gone. So now there is a provision in current law, and that's what you see in the next few lines down. Currently, the family division does have the ability to extend that jurisdiction. So almost think of it, the ability for them to be, for example, subject to the probation conditions of DCF and having to work with their case planner and that sort of thing. All of that can be going on while the family division has jurisdiction over them. So if you look at line 8, for example, right now, if the child was 16 or 17 then the family division can extend that jurisdiction to age 19, right? So it gives them another year. So if they committed the offense while they were 16 or 17, they don't necessarily automatically age out at 18, they get another year. So the proposal here is to add another year onto that. You see line 8? So if they're 16 or 17, the family division can extend the jurisdiction until you're 20. Well, until you turn 20. So it provides a period of time, a longer period of time. They already have some time. They can extend it, provides them a longer period, the court with a longer period of time to have the child be subject to their juvenile case plan, juvenile probation officer, all the other features of being a juvenile in a family group. Similar to the next.
Well, before Eric.
Yeah.
So I remember we had talked about this. Was there, and if I remember right, there was either some cases or potential cases of some of the younger offenders, I guess, getting into the system too late, was it, where they wouldn't have had a lot of opportunity, I guess, where fixing this age is going to give them more opportunity for some help.
Yeah, I think that's the idea. Yeah, exactly. And the same thing is going on in the next paragraph, subdivision, Roman numeral 2 there. Except this time it's, well, what if because we just talked about, what if the child was 16 or 17 when they committed the offense? Next paragraph down, what if they were 18? Well, because remember, under that first step of raise the age, the 18-year-olds are in the family division. They committed a non-Big 14 offense. So
Before I go any further,
Yeah.
the thing came to mind because, I mean, affordability is everywhere now. And I was just wondering if there was cost attached. There's got to be a cost. I mean, it's expanding services.
I don't know the answer to that, but that is a good question for DCF probably. And
No, I mean, it's extending the work of
Right.
DCF for
Right.
another year for these individuals. So yeah, that would be, I don't think there's a,
Right,
Either way, I mean, either way, is there an increase or decrease we can have?
and, right, are they being served by corrections now?
no, they wouldn't be. No, they're just
because
age
they're
out.
already in the
Yeah, yeah.
juvenile system.
Right, yes. They reoffend.
We'll make sure we ask DCF. Thank you.
yeah, so same situation as I just mentioned with the 18-year-olds you see on the next subdivision, which is that if they're 18, then it also increases by 1 year the amount of time that the family division can have jurisdiction over them. Right now, if it's an 18-year-old, they can have jurisdiction until age 20. They can extend it to age 20. It proposes to bump that up by a year to age 21. So those are your two pieces to reader assistance heading 1, family division delinquency jurisdiction. I'll move on to the next one unless there's any questions. All right, so now we're moving on to raise the age, starts on page 2. Again, quick refresher, everybody remembers that the first step of raise the age is already in effect. It has been since 2020. That was the 18-year-olds going into the family division for non-Big 14 offenses. Right now, the 19-year-olds, which is step 2 of raise the age, will also go into be treated as juveniles in the family division if they commit a non-Big 14 offense. And remember, that's scheduled to go into effect on April 1st, 2025. So just a couple of more months from now. That's when those 19-year-olds could be charged, would be, at least their proceedings would begin in the family division for those non-Big 14 offenses. So the proposal here is to delay the implementation date, not to repeal it. You remember, I think the administration proposal was repeal. This doesn't repeal, but it does defer it for 2 more years. So you'll see the way that's done mechanically is you look at sections 3 and 4, they just repeal everything that was raise the age related in last year's bill, Act number 125. That's 3 and 4. So that, you think about it for a moment, if those sections last year were supposed to go into effect, are scheduled to go into effect on April 1st, when do sections 3 and 4 have to go? The answer to that question, please turn to page 13.
Barely following.
27, right?
And look at
Dramatic.
subsection B, line 4, page 13. See that? Those sections go into effect the day before. March 31st, 2024. So that, in other words, repeals those sections before they go into effect. Because they go into effect on April 1st. You don't want to deal with, admittedly, it has happened before and it can be, and there is a way to deal with it and not unusual for it to result in litigation, but better to not have that happen if we can avoid it. And the way that you should avoid it, I would recommend, as a nonpartisan attorney, is if this passes, put it into effect the day before raise the age is supposed to go into effect on April 1st. That way it never happens. Sort of, it's way almost, if you think about it, you travel back in time, like a Star Trek episode, kind of. Before it ever happens, it's repealed.
It would have to pass out of both houses before.
Correct. It would have to do that.
Both bodies.
Oh, we have to sign it too. So
Yes, those things would have to happen.
all these things have to happen fast.
Right, right. So the next, any questions there? So the next, I think, 5 sections, sections 5, 6, 7, 8, 9, 5, 6, 7, 8, and 9, right? 5 through 9 up to pages 5. Those are the sections that implement substantively raise the age. So those were in Act 125 last year. And if you look at just in each section does the same thing. For example, page 3, line 7 changes 19 to 20. Also on line 13 changes 19 to 20. So it's just all these substantive implementations of raise the age, bumping it up so that the 19-year-olds will go into the family division if they're charged with a non-Big 14 offense. However, remember, as I mentioned at the beginning, this proposal is to have that additional step 2 of raise the age, the 19-year-olds, be delayed by 2 years. So it wouldn't go into effect until 2027. So if you turn back to page 13 again, to our effective dates section, and you look at subsection C, we just looked at B, those first 2 sections go into effect on March 31st. And then the actual raise the age provisions don't go into effect until July 1st, 2027. So they will be, have a delayed effective date. And you'll say, oh, they only apply to proceedings filed on or after that date. So if there was a proceeding that was filed against somebody before that day, that continues under the law as it existed at that time. And the 19-year-olds wouldn't be subject to family division jurisdiction until about roughly 2.5 years from now.
Just comment on that last point was one of the concerns raised by DCF if it went into effect April 1st, was that they'd all of a sudden have 125 cases that would transfer from criminal court to juvenile court. And saying that it shall only apply for proceedings filed on or after that date, it avoids that situation where all of a sudden when this goes into effect, that a bunch of these cases all of a sudden transfer. It would be more, they'd come in piecemeal, I guess.
So it pushes it out to 2 years plus it.
Plus anything
Staggers
filed,
it.
right, staggers it after that. I mean, part of the rationale for that as well is that you've already lost one of the main benefits of the juvenile justice system, which is the confidentiality, because it's already been in criminal court, and so. Okay, over to you.
All right. So that is the raise the age topic. I'll pause there before going into the next topic unless there's some more questions on that piece. Alrighty, so now I'm over on page 6. This is a proposal to establish a new option for transfer of cases, certain cases, from the family division to the criminal division. Now, just a moment or two of background so you can think about, well, what are there, when under existing law, can some of these cases be transferred from the family division to the criminal division? The answer is yes. You may recall there's a couple of different ways that can happen. For example, when someone who's age 16, 17, 18 commits a felony that's not on that Big 14 list, remember those have to start in the family division, right?
Yeah.
But the state's attorney can file a motion in the family division to transfer it up to the criminal division. So it's not one of the Big 14, but it's another felony. And if for whatever reason, the SA thinks that it is a case that is more appropriately handled in the criminal division, they can file a motion to do that. There's a lengthy procedure that has to be followed, filing a motion, having a hearing, findings the court has to make, et cetera. So that's one way. Another way, you may remember the youthful offender process. Remember that? It's another option, sort of another track that young people can go on if they sort of want to have, sometimes it's referred to as a blended sentence, because it's a situation that can come up when, for example, they've committed a felony that's also not on that list. There could be a motion made to transfer the case to the criminal division, but that can also be followed up by a motion to treat the case as a youthful offender case and then transfer it back down to the family division for youthful offender treatment. Remember, that's what's sometimes referred to as the ping pong effect, because the way it is right now, and we'll get to this topic, you can't file directly in the family division unless it's one of those big 14 offenses. But if it were a big 14 offense, then, and it wasn't filed direct, or even if it was, there's this option for motioning to transfer up to the criminal division as well.
Just to make clear, I think you said if it's a big 14, can't be direct filed into family division, right?
Oh, right, it can be, sorry, yeah.
It can be under youthful offender directly filed
In the family division,
the family division. Otherwise, it has to be filed in the criminal division.
if it's a big 14, exactly, right, yeah.
Thanks.
Yeah, sure. So this proposal is to create another option for what can happen when well, actually, let me back up. That youthful offender case. Let's say the case gets started and it's a YO, it's a youthful offender. Remember, the way it's set up is that there's terms of juvenile probation that the young person has to follow. And if they don't adhere to their probation, then there can be a motion for revocation of their youthful offender status file. And the court has an option now, which is to send the case back to the criminal division so that the child gets sentenced, right? Remember, that's sort of the carrot and stick thing. Hey, if you comply, if you go, if the youthful offender, a benefit and a downside too, if you don't comply with the probation. You could either comply and end up with no criminal record, or if you don't comply, you get sent back to the criminal division and you're sentenced as an adult. So that's sort of, in some ways, similar to what's happening here. So the proposal here is that not a youthful offender case, one of these, it's a juvenile case, so it could be like a 16, 17-year-old. And in fact, in this case, it only applies to an 18, 19-year-old. You have an 18, 19-year-old, they're in the family division, juvenile proceeding, and they don't comply with their terms of probation. That's when this option kicks in. Remember, it's sort of similar to this youthful offender. They don't comply with their probation under youthful offender, court can send it back to the criminal division. Same idea here. Provides an option in those non-Big 14 cases, as long as they're 18 or 19 years old, for a motion to be filed and for the court to send the case quickly to the criminal division. So it's almost like you could think of it as a repeat violator of probation. Doesn't happen in a first-time probation violation. Has to be at least a second or subsequent. So the language to look at really is on page 9. Sorry.
Karen, did you have a question?
Yeah, and maybe you're getting to, that's the piece I want to, are there parameters around the types of violations?
Getting there.
Yeah, well, there's certainly an age range. And that would be on page 9. So you see that if the child is attained at the age of 18, but not the age of 20, so it's 18 or 19-year-olds only.
Ian and Zach.
Just before we get to, you're about to go through and talk about the full thing.
Mhm.
Before we get there, I
Right.
guess that's a question about line 12 on page 6.
Yes.
So I see that you're mirroring the language from subsection 2 on another explicit condition of the juvenile probation certificate.
Right.
Which makes sense, but I was just wondering, does it need to be? Would it be simpler and just say that it doesn't need to be a condition of the probation, but just that upon a second or subsequent violation of juvenile probation, a violation of juvenile probation, there could be a motion for expedited. I'm just wondering, like, if we're trying to fill a hole here, and I'm just wondering if it needs to be so, like, another way where it could, that, like, if, for example, there wasn't an explicit condition in the probation.
Yeah, I don't think it's necessary, so I think you don't have to have it. That piece that you noted and the language over on page 9, not that, but on the top part of page 9, which has to do with what the court has to explain to the juvenile in the context of their probation. These are just included for purposes of providing notice to the juvenile about, hey, just so you know, here's a possible consequence of what could happen if you don't comply for a second or subsequent time. That's not, I don't think that's necessarily legally necessary, but I just sort of fit that in as part of a kind of a full notice provision.
And then the only other question I had about it was, line 15, the court may transfer the case. Do we need to put in here like what the mechanism is? So it's upon motion by the prosecutor, or can the court do it on its own? I think if I read not from page 9 forward, that it's a motion by the state.
Or the court.
Or the court can do. Okay.
Yeah, but I think there's nothing wrong with saying upon motion, may transfer the case upon motion.
Does it have to be? It has to be because you got the notice issue, because you have the hearing on it, right?
I missed that, sorry.
There's a notice issue. You would need to have some kind of motion so you'd have a hearing so that the juvenile had notice.
Right.
Yeah. Okay.
Yeah,
Okay. Those are my questions. Thank you.
for sure.
Yeah.
Sure.
Zach?
Thank you. Oddly enough, my question's also on page 6. Thank you. So Eric, and I'm just trying to get up to speed on this as well. So I'm just,
Sure.
I appreciate your insight and you walking us through this. But looking at the ages of 18 to 20,
Mhm.
I'm curious, well, one, what happens beyond 20? What happens under 18? I guess so that's part one of the question.
Okay.
Yeah, sorry. Demarcation point, what happens under 18 and 20 then?
I didn't know if the segue was
The
coming.
next part's coming.
Perfect. All right. So for the below 18, what happens is this additional option that wouldn't apply for them. So they would be subject to the current juvenile probation chapter, which is, that they can't be transferred to the criminal division, though they have the options available to them under current law that I think earlier on when we first had the hearing over in the Pavilion Building, you guys talked about, that's the chapter on juvenile probation that gives the court, they can implement more conditions of probation, try and add criteria to get them to comply, maybe add more case planning, that kind of thing. But they would not, because they're still outside the age range of kids that can be brought in the criminal division, they would not be able to be transferred. So it's
I
only.
understand. Yeah. So I guess that brings me to my next question is, well, how did we arrive at 18 to 20?
That was just a policy.
That was a policy.
Yes, yeah, exactly.
Because the thing that is concerning to me, and I'm just curious about your thoughts on it, is it seems like we're arriving at ages in a rather arbitrary manner. And I say that only because you go through this and there's all different kinds of age ranges, right? So we're upping it from 10 to 12. We're upping it from 19 to 20. It feels like and then I'm looking at line 15 and 16 on page 5. We're starting at 16 and going to 19, but now we're moving that to 20. It just seems, I'm just kind of curious, like what's the science? Because it seems like it's becoming an art, a policy art in some cases. Like there's a very deliberate choice that's being made. And I'm just curious, like, what's the logic there? Like, I'm just trying to figure this out. And I think a lot of people would be asking similar questions.
I think it's without commenting on which number is the right number. I would say that in any case, I would say that generally speaking, the selection of the ages is an attempt to have the law and the policy match the severity of the behavior, the nature of the defendant, where they are on a developmental stage, all of those things, which are very admittedly complicated to figure out. So, but I think that's the best attempt to do that.
Yeah, admittedly. And I think, I mean, the concern that I have, and again, this is directed towards you as the one providing witness and testimony on this,
No worries.
but not directed at you personally. The question that I have is, as convoluted as it is me articulating this to you, I think a lot of people, if they're, any of our constituents reading this, I think would easily be confused and trying to understand, are we saying that those under 16 are not capable of the crimes and the punishment that those over 16 are, and all of a sudden under 20 and then up to 22? It just seems like in an effort, this committee, consistently, I think, has undertaken the priority of streamlining and making things more simple, especially in the judicial code, which I think is very admirable. And it seems like this is as convoluted as it could possibly get. I know that's not a question, but it's certainly, I think, a pertinent observation. So I'll yield back to the chair at that point.
I will not disagree with what you said as far as convoluted, and that's in part, we're expecting a report in December that will hopefully, consistent with what this is, restructure how this is done. Because if you recall the chart that Marshall provided,
Yeah, it was very complex. Yeah.
Right. And if you try to figure that out by looking at the statute, I think it's darn near impossible, frankly. And so that's an effort that we put into effect last year, requiring this group to get together and come back and essentially saying, simplify this.
Sure.
And so we will be seeing that.
So I guess the question I have for you, Chair, is if the report is coming in December, would it be prudent to wait until the report comes out to try to realign this?
Maybe.
Because it seems like we're rushing to get something done that I just don't doesn't seem possible.
So here's my thought on that. And so my thought on that is that we have raised the age right now, goes into effect April 1st. I know administration wants to repeal it. I've got a lot of pushback and we're not going to repeal it, but all right, well, let's delay it. But I've also heard a bunch of other things, including about accountability and the gap when you're 18 and 19-year-old. But rather than just say, we're going to push this off till July of 27, which is what I'm proposing, I'd rather try to take a shot at fixing some of those. Yeah, and maybe it's not going to work. Maybe at the end of the day, we just either let it go into effect on April 1st, which I don't intend to do, or just do the delay. But let's take a run at trying to fix some of these things and hopefully not confuse it more than it is, and hopefully in a manner that can be incorporated into whatever we see in December. And so I'd rather have this kind of out there, which isn't good. All the stuff we're talking about right now, it wouldn't go into effect until July of 27 either, this accountability thing. So that'll be out there if we manage to solve it. And I will anticipate and will ask and make sure that that group who's working on that for December kind of can incorporate the fact that we're trying to get a different level of accountability for 18 and 19-year-olds. So yeah, it's messy. And I'll absolutely grant you that. I think a couple other things that we have in here aren't, but we'll see. This is a proposal. None of this might work. We're going to get this has not been run by any of the stakeholders. This is just from what we heard and Eric and I talking about it, and Ian weighing in a little bit as well. And so, but your point is absolutely, I understand where you're coming from on that.
I appreciate that. And I just think with town meeting day coming up and a lot of constituents following what's happening in all of our committees, I think in public safety being namely a huge concern and accountability in our communities, I think me coming back and trying to explain something like this, I mean, I think it's
the legislature.
well, no. Again, I would say it's not an inability or a lack of interest in explaining it, but people would be left scratching their head.
Sure. And that's a matter of, they would be left scratching their head if we tried to explain the juvenile justice system as it is right now, and probably as it is even with the December, what we're hoping to simplify this. My message to community, if this goes through, is that we've raised the age for 2 years, over 2 years, because of the testimonies we got. And we are putting into additional accountability for when that goes into effect. You know, that's kind of the extent of my messaging really on this, is that we're going to put in accountability, but we're going to push this thing off because we're not ready.
But do you think there's a concern optically in a delay of accountability for until 2027?
Well, we're not raising the age. I mean, there is 18-year-olds, and maybe we're going to hear from folks, if my accountability thing is wonderful and everybody likes it, maybe we put it into effect. You know,
We expedite,
18.
yeah.
You know, so, but right now the proposal is that it goes in when the next step happens. But yeah, yeah. So, but that's what I'm after, is trying to get the accountability that we heard there's a gap in it.
Yeah, and no, I think the intent is
Yeah.
spot on. I just
You make a good point. This is
bring
not
more questions.
the easiest area. Ian, yeah.
Is it okay if I?
Yeah, we're, yeah, no, with the walkthrough, we can have a little bit of a discussion as we're going through.
Absolutely.
Appreciate it.
I just wanted to ask, reading this, is the intent that if you were on juvenile probation, Eric, when the probation was formed when you were 17, when you turned 18, there would need to be a condition put in as of 3? Or is it only if you're 18 when you enter probation?
I don't think that particular issue was one that was decided conclusively, or even,
Good question.
it's a good question. Yeah, I don't know.
Yeah, so we maybe want, and I'm just, I think the way I read that, it would be if you entered probation when you were 18, then
Right.
there would need to be an explicit condition. But if you were 17 and you then turned 18.
Right. That's what I think. That's what at least my thinking was. We're trying to go after, target, whatever you want. Specifically those who are entering probation when they're 18 or 19.
Because the testimony you heard was that if you're 18, there's not that much time and there's no incentive to complete because there's no risk really.
Right, because DCF can't. But then again, if you turn it, that's another issue that we can talk about. This
Yeah.
because the idea is that under 18, DCF can take custody. People can, yes, not really incarceration, but can be detained in different manners. Whereas after 18, it wasn't. After 17, that's not fair.
Yeah.
But you're right. So the 17-year-old turns 18. But then, you know, maybe this accountability applies there as well, but it'd be a little bit difficult if somebody was in there at age 14, 15 or whatever, and then all of a sudden they're going to send them over to criminal court if the
Yeah. I mean, is someone
offense was committed when they were 16 and now they've turned 18 and they violate probation finally. So something that we can make it seem even clearer for Zach and
I mean,
I would not support that.
You would not support that. Can I just be clear? I actually wasn't advocating this.
I didn't think you were.
I was just
a
reading it,
great
trying
question.
to decide whether I thought that was the intent or not.
Yeah.
That was not the intent.
That was not the intent. And I'm
Great
actually
question.
reading it, I don't think that's how I would read it either, but yeah, okay.
Is there a way that we
Clarity
can
is
make it clearer?
Yeah, that is important.
Yeah.
I think you have two separate issues is should the certificate say? And when does the procedure option kick in? The two separate things, you know, just by saying something in the certificate doesn't necessarily change what the underlying law is. So it could be that you decide, and it might be easier that every certificate has that in there about what happens when you're 18 or 19. Because it could happen. Let's say you're start on probation when you're 15. Yes, one of your violations when you're 16 or 17. No, that doesn't kick it in. But you still might want to know that, hey, because plus mechanically, what does the court do? Reissue the certificate of probation when the kid turns 18, after they already had one when they were 15? So that.
Or do we just make clear in the section 12 that this applies to those who enter the delinquency at age 18?
Could do it that way too. So in other words, someone who entered juvenile proceedings at age 17.
Yeah, we're keeping them until age, what, 20? Is that what we're saying now? 19? Ever?
But they wouldn't be transferred,
Right.
even if they violated when they were 18 and 19.
But as it is, it could be, but I'm just saying, but I'm thinking more of the age is 15 or something. You know, you're getting a long ways away from that initial offense to be sending them over to criminal court to start again. That's my concern.
I see.
If it's like 17, that's a little bit different, but you know, where do we draw? We draw lines in here. Sometimes, in fact, they are arbitrary. Or they're dictated by politics and policy and all those things. Anyway.
Well, I was just gonna, I don't know if we're actually discussing this or not.
Well, this is an issue that came up and we're
I just-
exploring this to
I
see what
think
else we might tell Eric.
If we were to move in that direction and say that like, if you're on probation, when you turn 18, no matter when probation started, that there is now this new condition or this new, call it a new condition. I don't like that I have a number of problems with that, but one of them is it really just supports this false narrative that something magical happens on your 18th birthday and you turn 18 and all of a sudden your brain has changed. And we know that's not true.
Right.
And we're fighting that already by again delaying this change. And so I would have a lot of issues with.
Right. So, I mean, I think that the cleanest thing at this point, and we make also incremental progress in an arbitrary way, is that what we, no, I mean, that we make it clear it's somebody who enters at 18 or 19. That's what we're trying, that's the population that we're dealing with now. And if we want to try to deal with those who are 16, well, we're partly trying to deal with those who are 16, 17, 18 is to raise that upper age so they're not aging out before there's more time to actually. So, yeah.
And just so we all remember, we're not talking about when someone enters. We're talking about when they are on probation. So that's actually once they're found delinquent. And I know that there are expedited timelines in the juvenile court, but they're not, as we heard testimony that we're not always complying with those timelines. So someone absolutely, the offense could have been when they were 16 or 17, and then they finally are found delinquent when they turn 18.
But they would be in the juvenile court. I mean, so it's
agreed.
I think when the offense occurs is when somebody goes in at age 18, right?
No, I mean, that's not how I would read this at all. This is when conditions of probation this is when you are on probation, which is after you've been found delinquent. So that's once the adjudication is over.
But the raise the age to go to 18 meant that it's when somebody commits the offense at age 18 and that they would go into, they go into the system. It may take a little while to actually be found, for the adjudication to occur.
Yeah.
But if they go in at age 18.
Yeah, I'm just pushing back a little bit against the argument that because how far back the crime or the thing occurred, if it's further back, that because of where we're talking about in the system, this is at the end, that the actual underlying event could have happened a while ago, even if you're getting somebody when they're 18, when they're found delinquent. Am I making sense or I'm not making sense?
I think so, but I think again, the key for raise the age of 18 and 19, we ever get to 19, is that's when the offense was committed. And that's why you are able to go into delinquency is because you hadn't turned 19 yet and you offended at 18.
Yeah.
Now you could have offended at 17 or 16 or whatever, but it's that upper age group that we're concerned about.
Yeah. Okay. No, I see what you mean. Yeah.
All right, so we'll continue though.
Sorry.
No. We're going to have plenty of discussion next week on this as well. This is our session bill, which will maybe vote out by the 13th of March in some form or other. Over to you, Eric.
Yes, I would just close that topic by observing also that I think that if we, again, maybe changes in what the committee intends with this language, if whatever it may be, but if it ultimately is the case that you intend that this expedited proceeding be available only for a person who was 18 or 19-year-old at the time they were charged with the offense. In other words, that the juvenile proceeding was open against the person. We'll need to add language.
Right.
Yeah.
Which we won't do until we've heard from.
I know. Yeah,
So
absolutely.
we'll stick with this one
Yeah.
for next Tuesday and Wednesday, but this is definitely an issue that will need to be further explored.
Right. Well, it's good that the language, sort of puts you in a place to talk about that, leaving it open.
Yeah.
In retrospect, it was intentional. You drafted that.
Drafted.
Yeah, exactly.
Prompting conversation.
That was the hope. All right, thank you.
You are a master.
All right, thank you.
One quick question, I don't know if it was asked or if it was said, in 2 years, when it goes into effect and more people going into the system is gonna be staggered, is DCF still gonna be able to handle it if it's staggered without additional resources? They would need additional resources now because they're under-resourced now. And if their resources aren't increased in the next 2 years, they still won't be able to handle it. And we'll be right back here.
You have to collect testimony is what it sounds like.
Right.
Yeah, oh, I agree. The DCF needs to be added. One way or the other, they have more resources.
But we can give them a long runway.
Maybe DOC will need you.
They've had a long runway.
We're a long ways down that runway today
But maybe this will-
already, and they're still.
Oh, I did not
Under-resourced.
mean to bring in the airport again. That was a mistake.
I didn't get the connection.
Yeah.
But yeah, I mean,
Sorry. All right, Eric, go ahead.
Yes.
Section 12 maybe, or maybe we're at page 9 at least.
Page 10 is where I was going to go, but just to
10.
kind of, we talked a second about, who this proceeding is available to. Well, how does it work? That's really what we're talking about on page 10. You had just, someone had just mentioned the timeliness of the hearing. So you have to have a hearing. That's subsection B, top of page 10. And has to be held in accordance with the juvenile probation hearing procedures that are cross-referenced there. That just means the child gets to have an attorney. There has to be notice. There has to be an opportunity to cross-examine witnesses, et cetera, et cetera. So that's all that refers to. Now, timing, you'll see is in the next line, there's an expedited timing requirement here. As soon as practicable, but in no event later than 15 days after the motion is filed. So the idea is to try and move this proceeding along. Similar to the youthful offender revocation hearing that I mentioned, that can be joined with a violation of conditions of probation hearing. So remember, this sort of is dependent upon that a probation violation has occurred. So it doesn't really make sense to have two separate hearings, have them together. All right, so what does the court have to find? We're moving on now to the rest of the page. Well, it all depends on line 7, the nature of the probation violation. In other words, like what happened, what was the probation violation, and whether it demonstrates that continuing to treat the youth in the family division poses what's called an unreasonable risk to public safety. So the court's got to weigh whatever it thinks it's relevant. And there's a hearing procedure here in which, as I mentioned, parties have an opportunity to present evidence and cross-examine witnesses, make their arguments as to whether or not that connection exists. And it all depends on that connection, because if you look at the next two subdivisions, the next one, subdivision 2, if the court does find that the probation violation demonstrates, I'm on line 11, continuing to treat the youth in the family division poses an unreasonable risk to public safety, what happens? The motion has to be granted to make an expedited transfer. Case is immediately transferred to the criminal division, and the state's attorney commences the criminal case like in all other cases, as though the juvenile proceeding had not occurred. But you look at the next subdivision B there, and any information that came about in this family division proceeding is going to be inadmissible. So that's the idea there, is to, and this is modeled on the language that's in the need screening language for the youthful offender proceedings about information coming up in that type of analysis, not later being admissible or used against the child. So whatever was discussed, or there's some exceptions there for plea agreements, but other than those two references, everything else is going to be inadmissible against the child.
And can you distinguish that outcome from youthful offender?
Yes, you mean in terms of
When
the,
it's transferred to the criminal court? Just the effect when it gets transferred to the criminal, court. It's not going right to sentencing, it's going.
correct, exactly, exactly. It starts from the beginning.
Right.
So it's not like there's been any admission or you're not going right to an arraignment in the criminal court. It's as if, as I mentioned, I think the proceeding had not occurred. So it's really starting all over from scratch, and nothing that happened previously is going to come into play or be used against the child in the criminal proceeding. As opposed to, as you mentioned, the youthful offender proceeding where it really goes to a sentence because they've already made that agreement before they went into the YO status.
That being a main distinguishing factor between the two. Angela, then Ian.
It's just occurred to me, I could be totally off base. How is this not like being charged for the same time twice? Because you were never charged in the juvenile proceeding?
Correct.
So we were-
Not a crime.
That's a case on this called Breed v. Jones from 75.
Right.
It says the prosecution and the juvenile delinquency court,
Introduce yourself real quick.
Marshall Paul from the Office of the Defender General, that it is the jeopardy attaches when you're prosecuted in the juvenile court. And so you can't be prosecuted in the juvenile court and subsequently prosecuted in the criminal court for the same offense.
Oh, we have to fix it.
So I'm not totally off base.
So, and we're gonna hear a lot more from Marshall, I'm sure, on in this bill.
So it may have to be a transfer rather than a restarted proceeding potentially. I don't know if that would be a way to address that, but I haven't read the case, so,
Transfer.
right.
So we'll have to, what's the name of the case, just so we,
Breed v. Jones from 75.
Jones.
Did you say brie like the cheese?
Breed, P-R-E-D. It's 421 US 519.
All right, thanks. We like to stay constitutional.
Yes. Always preferred.
Ian and then Ken.
Is unreasonable risk to public safety, where does that come in, that language?
I think it was just an attempt to craft a standard that gives the court some discretion and the opportunity and the parties the opportunity to file whatever evidence they thought was relevant without using a long list of criteria or factors, which, for example, you do have in the youthful offender violation context and in the context of transferring a case for, like, say, a 16 and up, when I mentioned earlier that there's that option available when, it's a non-big 14 felony and the state's attorney can file a motion to transfer. Now, there's a lengthy list of criteria for the court to consider. I think the idea was to be leave more discretion rather than have a prescribed statutory list.
Okay, I was just curious if it got pulled from somewhere else in the title, or I don't really know any reason why it's not a good term, but I'm just curious.
Right.
We heard some testimony yesterday from Judge Zone about not having timelines without remedies. So we're putting in a 15-day timeline off this motion with no remedy if it's not complied with. Is there anything that we could put in there as a remedy for someone if the hearing wasn't set within 15 days?
Sure. It's a total policy decision. Yep. You certainly could put in something that said, if the motion's not filed within 15 days, it shall not be permitted. So you could have the consequence be as serious as if they don't get it in time, then you can't file it if you wanted. A total policy.
And then my last really quickly is just, I think it does make sense about being able to have both the hearings at the same time, but then it kind of makes it wonky with page 6.3 that you can file, or if they say you file a motion upon a second or subsequent violation, can you actually file the motion without having the subsequent or second violation.
Yeah, and it is sort of a sort of chronological thought that occurs in mind, but with the same one, I know the same one exists in the youthful offender context. That's what
Okay.
it's based on. And the youth offender is similarly, when you file a motion for revocation of youthful offender status, the similar language exists. You can join it, which is dependent upon probation violation.
Yeah, yeah.
But also said you can join the motion for revocation with the underlying motion for probation violation. So I think it's just,
Right.
you're right, it is sort of temporally, I guess. You sort of think, well, doesn't that one have to occur first? That's true. But I sort of base that on that
Yeah.
existing.
If it came from other, that's
Right.
great.
Okay. Ken,
I need some help. Trying to understand this.
Right.
I'm a little slow. If I'm understanding this right, this is a way the raise the age goes into effect in October or something like that to 19,
April 1st.
April.
Right.
We're the only state that's going to go to 19. Right? Around here. Massachusetts isn't even there, right?
I think that's correct, yes.
So more than likely we'll have maybe nice people coming from Massachusetts up here and doing whatever they want. So anyway, that was facetious, but not really. So I think what this bill is getting at is trying to delay that until 27, which is kind of honorable. I'm still against it. This going into effect April 1st, whatever it was,
Right.
whatever it is. For this to be, can this be vetoed before
So
April 1st?
Sure, it all depends on the timing of when when or if it passes.
How soon it gets through here, how soon it gets through the Senate, correct?
Yes.
But if people wanted to play politics, the way we know this building can be played, this could be held up on this, not being taken care of and not being dealt with, and it goes into effect April 1st and we can't stop it. Because it'll never get to the governor to veto it.
So if he vetoes this, it goes into effect April 1st, just to be clear on that. There's nothing out there that would keep that from going into effect other than doing something like this where we're delaying it.
So another way of putting this is we're just kicking this can down the road until 27. So basically, to put it quite bluntly, because I'm not for raise the age,
Right.
I'm being held to go and to go with this, whether I like it or not. If I want to stop raising, if I want to delay raising the age.
At this point, yeah, I mean, I think this is the vehicle we have to not have this go into effect April 1st. Now, again, I put out, that's one of the goals that we have is.
No, we don't have, you have.
No, I think it's pretty universal that we don't want to go into effect April 1st. I think that's not universal, but I think most people don't want it to go into effect April 1st. I mean, I could just delay it. I'm not going to repeal it because there's been too many people who have good testimony that this is something we should do. And a big problem is that we're not ready for it. So, I'm not interested.
But
in
we're the
repealing
only
it.
state.
What's that?
We're the only state.
Fine, but I'm just saying the reality right now is I don't see me being able to get a bill out of this committee because I myself would vote against it if it was repealing it. I'm fine to give it a good long term before it goes into effect and hopefully we can be prepared by then. But I'm also trying to deal with some of the other issues that were raised during all of our hearings. That's what the other things are doing, including one that Eric will finish up with in a second, but. And we'll have more discussion about this. We're gonna have a bunch of people in, including, DCF and other folks, so.
So just to go back to what's going on in my head. Unless I go along with this, well, doesn't matter really what I do anyway, but the point of the matter is, if I don't go along with this, there's no way of stopping the raise the age from going up.
That's not true.
Yeah, that's not necessarily the case. Is there another bill out there that's gonna pass through the whole body? Probably not. Probably not.
Is there a bill I can get to the governor that he can veto before?
Well, no, again, a veto just leaves the status quo, which is April 1st, this goes into effect.
We've already passed, this is Act 127, right?
Right.
Hmm.
127 was education.
125.
Oh, it's one.
Ken, I am trying to push off the April 1st date.
And I
And I'm
respect
not in a
that.
position
I respect
to,
that.
to have it repealed. And in fact, I don't think it should be repealed. I think it's a good idea. It's just that we're not ready for it. But, so that's my main goal, but why not try to resolve some of the issues that we've heard raised during 4 days of testimony? And we have time, we have a little time to do this. I'm hoping to get this out before, town meeting week. But, Senate's not gonna get to it until, first week probably after crossover. They know that it's coming. I've kept them informed. We're trying to make it so it can all go through in time for hopefully the governor to either let it go into law or to sign it into law. Whatever we end up through this process over the next couple of weeks with this as the starting point.
When did 125 go into effect? In the last 2 years?
Last year, you passed it.
Last year.
Yeah.
How convenient.
Yep.
Well,
You good? I mean, you may not be good, but can we proceed? Angela?
before 125, there was a law that was signed.
Yeah, it was gonna go into effect last July.
Signed by the governor. The Raise the Age Act of 2018.
2018.
2018. Had 18 and 19-year-olds coming under juvenile jurisdiction at a staggered, on a staggered schedule, and has been delayed. That bill in 2018 was passed the House, the Senate, and was signed by the governor. That bill is actually what we're dealing with now. It's not just 125 from last year. 125 was dealing with Raise the Age from 2018.
Right. What's back?
So it's not something that conveniently happened last year.
Thank you for that clarification.
Eric,
Yes,
section 13.
the very last section.
And there's gonna be I can see some fun conversations in the next couple of weeks. I'm looking forward to it.
That's fun.
The last topic you'll see in the reader assistance language on page 11, line 6. It uses the language repetitive transfer between family and criminal divisions. That's really a nice way of saying ping pong. Tried to think of a way to say that wasn't used in the reader assistance. And that, remember, I sort of alluded to this earlier. That's the idea that for youthful offender proceedings right now, they can only be initiated by either a direct file in the family division for a case that could have been in the criminal division, which means it has to have been a big 14 offense, or it has to be transferred down from the criminal division. So if it's not a big 14 offense and someone wants to file a motion to have the case be treated as a youthful offender case, it has to be filed in the criminal division. But what if those cases do start in the family division? So it requires two motions. First, a motion to transfer up from the family division to the criminal division, and then another motion to transfer down from the criminal division to the family division. The idea is that's what some people have referred to as the ping pong effect. So the idea is to try and address that a little bit. So 2 years ago, you did address it in part. If you look on page 12, so lines 7 through 11. So this is just basically saying, all right, notwithstanding what I just described, notwithstanding the fact that there's this ping pong requirement generally. You put into place line 7 and 8. You said, okay, well, we're going to make an exception to that ping pong procedure. And that exception is going to be when the parties agree at the outset. The parties agree at the outset, hey, you know what, this case in the family division really should be a youthful offender case. Well, then they can stipulate to it. And then in that case, you see they can stipulate it and convert it to a youthful offender proceeding on 52A. So as long as they agree. So this adds another option to convert the case to a youthful offender proceeding. It can be done, you see on line 9 now, a motion could be filed by the state's attorney, the defendant, or the court on its own motion to convert this proceeding. So it allows another method, if you will, to get from the family division to the criminal division, from the family division to a youthful offender proceeding within the family division without having to take that sort of alternative route up to the criminal division and then going back down. So that's the idea. You will see at the bottom of page 12, if that motion to convert the proceeding is denied, well, then it remains in the family division as a juvenile proceeding, which is the way it was beforehand. That's kind of the idea. Allows a different track, if you will, for the conversion of a juvenile proceeding to a youthful offender proceeding without having to take that sort of roundabout route through the criminal.
Questions on that one? And again, we're going to be getting a lot more testimony, including on Tuesday, Wednesday next week, when we're scheduling a bunch of folks. You'll getting an invite soon on that. So thank you.
Yes, I think we already went through the effective dates. So no need to go back there, I think. We sort of jumped ahead to this during the sections we were talking about. So I think those are already covered.
Great. I appreciate it. So
All right, thank you.
we'll get
Thank you, Eric.
You bet. Thanks.
next week. New one.
Nice and easy.
Yes.
It's nothing compared to that.
Yeah, let's take 5 minutes.
It's okay.
Compared to what feeling?
So we'll go off live for 5 minutes. And really 5 minutes this time, because we don't have that much time if we want to. Well, I wasn't talking to you, I'm to other people.